right? He's on page 1. Yes. Okay. Yes.
If I want, I'm sorry. Judge, I went ahead and filed a motion for continuance. I have a really complicated week. In the motion, you will see in addition to the setting, which I'm in the middle of trying to get.
All right, so I know you say you filed the motion, but you'll need to get them to print it out because if you filed it by e-file, I don't have it.
Down there right now.
Okay.
But what's in the motion as well is I've been working on a manslaughter case. And we finally got a date.
Okay, so let me just tell you. Let me just tell you, I appreciate everything that you're saying, but until I see the motion, there's nothing I can do.
I'm just trying to give heads up. I know you are.
You're giving me a jacket cover on the book. You're like, hey, let me just tell you what's going to happen in the jacket cover.
I'm transparent, Judge.
Yeah, no, I appreciate that. So once you have that before me, and I'll take it up.
I'll be right back as soon as I can get it to the judge.
All right, thank you. Sure. All right, who's here? Larry Garcia? Are there any applications in this case?
No, Your Honor.
All right, court is calling 2025 CR 007787 State versus Larry R. Garcia. Can I have parties announced?
Lauren Espinoza for the state of Texas.
Robert Gaona for the defendant.
And are you Mr. Garcia?
Correct, Your Honor.
Counsel, have you received all discovery?
Yes, Your Honor.
Did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Garcia, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Garcia, did you review the court admonishments with your attorney?
Yes, I did, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
You're charged with possession of a controlled substance, penalty group 1, less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea agreement with the state, the court does not have to follow that plea. If for any reason I don't follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I do, Your Honor.
All right, and probation, this is not an application. Counsel, I'm sorry, sir, did you understand you have a right to jury trial?
Yes, Your Honor.
A right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
By entering the plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
I am, Your Honor.
Are you a U.S. citizen?
I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did, Your Honor.
All right, according to the plea, the state is asking that your punishment be assessed at 108 days in the Bexar County Jail under 1244, and there's a $500 fine and no applications. Did you understand that to be the plea?
Yes, Your Honor.
Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney?
Yes, Your Honor.
Did you understand it
I did.
and sign it in both places?
Yes, Your Honor.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
I did, Your Honor.
Counsel, have there been any such motions?
No, Judge.
To the offense as charged, how do you plead? Guilty, not guilty, or no contest?
I'm guilty, Your Honor.
State, any evidence?
Yes, Your Honor. State offers into evidence what has been marked as State's Exhibit 1 in all attachments.
Objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney?
Oh, yes, Your Honor.
Did you understand it?
I did, Your Honor.
Did you sign it in all the appropriate places?
I did, Your Honor.
Again, did you understand you have a right to jury trial?
Oh, yes, Your Honor.
It's a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand?
I understood.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
I understand, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. Cindy, do you need a cough drop?
I've got one in my mouth.
Okay.
Taking a sip.
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge,
Anything you wish to say on behalf of your client?
only to accept the plea bargain we worked out with the state, give them credit for time served and judgment satisfied.
All right. The court will find you guilty as previously stated. The court will sentence you to 108 days in the Bexar County Jail under 1244. The court will give you credit for any time served. There is a $500 fine, time and money to run concurrently. Counsel, does he have exactly 108 days?
On the docket sheet, it says 107, Judge. So
All right, so here's the thing. With regards to jail time credit, I can only give you credit for the amount of time you've served day for day. The sheriff's office, they're in charge of whether you receive 2 for 1 or 3 for 1. I'm not in charge of that. What I can tell you is I've entered a sentence of you of 108 days in the Bexar County Jail. So if you have 107 days today, maybe they'll release you today, or maybe they will say you owe them another day. That's completely up to the jail. Do you understand?
I understand, ma'am.
Now, if they keep you there past 108 days, then your attorney comes back here and we'll find out what's going on.
I understand.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, we can go off the record. You're gonna have to change your life. How old are you?
35?
All right, you're 35. Now, you're receiving a guilty verdict in this case. That's the easy way out for you. And you're like, hey, this is great because I want to be out of jail either today or tomorrow at midnight. Why they choose midnight? Again, that's the jail. But at the end of the day, if you have an addiction and it's addiction to heroin, that's a major issue. And unless you get help for that addiction, time you leave the Bexar County Jail, since you've been there for 107 days, probably gone through detox, what's going to end up happening is you have these plans, right? I'm never going to use again. I'm getting my life together. I'm going to get my family back in my life. And then the next thing you do, you hit freedom, you smell the air, you get involved with somebody because you're supposed to change people, places, and things. And the next thing you know, you're using. And the last time you use could be the last time you use. When you get out of jail, you know what the first thing you should do before you call family or anybody and make promises about I'm changing my life? You need to find yourself a meeting and go to a sober support meeting. You need to find yourself a transitional sober house to live in. If you cannot find any of those things, you come back here, I'll pick up the phone, call somebody to help you. But nobody can help you if you don't want to help yourself. You understand? So don't call family making promises that you're going to maintain your sobriety when you haven't been tested yet. You understand?
I understand.
All right. Good luck to you. Okay.
Okay, thank you.
You're welcome. Anyone else ready? Thank you. Miller?
Ready on that, Judge.
All right, Mr. Miller, come down. Okay, I'm assuming this is just a late indictment, even though it has 2023.
MTR? It's the, I think that's.
It's on
one's
page
MTR, Judge.
6. This is a motion to revoke.
There is a motion to revoke, but he also has several unindicted cases, Judge.
Are we proceeding on the motion to revoke?
Not at this current time, Judge. One discovery on the others. I mean,
Okay.
he has 1, 2, 3, 4 additional cases. And we had an opportunity to look at it today. I didn't really have an opportunity to evaluate those.
Mhm.
And I was hoping to get a small reset to look at that, because I think that some of them are going to be taken care of in an intake. And I just didn't want to hold that against him.
Okay.
Yeah.
So when do y'all want this recalled back?
Judge, I'm fine with next week. I've got 2 trial settings here next week, so you're gonna see plenty of me.
All right, do y'all want to recall this back for the 25th? Or the 26th? Or the 28th?
28th would probably be the best, Judge, so that we could get a little time just to, if that's okay, Mr.
Yeah, and that's one of the trial settings that I actually have. It's actually a discovery setting, Judge.
All right, so we will be back on August 28th to see what's happening with your other cases.
Thank you.
All right, thank you. Do you have any questions about anything?
Oh, no.
All right, we'll bring you back on August 28th.
Thank you, Judge. We've
Thank
made
you.
your excuse.
Yes. Well, I mean, you may be excused.
I tried, Fred. Good.
I'm sorry, I missed the date.
It's August 28th. You're welcome. You're welcome.
And then they have it. The last pages that were.
Oh my gosh. So anyway, it's from, I allow people to use my chambers if they need to do their breastfeeding and also for prayer. Let me see. This is so beautiful. Oh. I'm loving this. And it smells beautiful. I'm like, wow. This is good. This is beautiful. Oh my gosh. I love it. You know, you never know where the day is going to take you. The day will always take you to different places. And you know, you think it's not going to be a beautiful day, and somebody makes your day beautiful. You know, that's what Deputy Lord, that's all I always tell people. You can always do something. People will think they're having a hard day, and they're not. I love the arrangement. All right, State, have you had a chance to review this motion for continuance that's being requested on Jeffrey Smith?
It was just, I just was told about it, Judge.
Let me know if you have any objections.
Okay, Judge. I briefly went over it with the defense counsel, Judge. The state wouldn't be opposed to it.
All right, and you have no objection because it's not in the proper format?
No, I don't have any objection to that.
All right, some people do. Jeffrey Smith. Cindy, we're gonna go on the record. Court is calling 2025 CR 002-103 State versus Jeffrey Smith. Can I have parties announced?
Jason Garahan for the state, Your Honor.
Tilden Schaefer from Mr. Smith.
And are you Mr. Smith?
Yes, ma'am.
All right, defense, you filed a motion for continuance. Defense, you're aware that we have a jury trial scheduled, but you do not want to risk being called. Is that correct?
I have, Judge, I can't be three places at once as part of the law. And in part of what the motion is talking about is we have two witnesses in this case that we've been trying to get since June.
Well, I hate it. Well, I shouldn't say the word hate, but as a defense attorney, I never liked burning a motion for continuance if I didn't have to, but.
I understand that, but the confluence of events in my practice, Judge, are necessitating this. It's an extremely delicate 36 hours for me. And I think my client deserves my undivided attention. I don't like burning it either, Judge. Yes. But
Okay.
I just think this is the prudent thing to do.
All right.
Or unless the judge is willing to say, you don't need it.
Well, I mean, I'm just saying that we have a jury trial that's scheduled this afternoon. And unless they enter a plea bargain agreement and I accept it, which I don't think they're going to enter a plea, that trial is going to go. And then there will be another trial that will be scheduled before your clients. But if you wish to continue with the motion for continuance, I, of course, will hear it.
Well, let me confer on this 11th hour news, Judge.
Yeah, okay.
We're going to continue with the motion, Judge.
All right.
I've got to leave town in 42 minutes.
Okay. You have co-counsel here, but okay.
I understand that, Judge.
All right.
You hired both of us. I'm primary counsel on the case, Your Honor.
All right. So state any objections to defense counsel's motion for continuance?
No, Your Honor.
All right. That will be granted. And then this case will be recalled. We can go off the record. When do you expect to continue with what you have in the other counties?
I'm not sure what I understand your question.
When are you going to be finished? You know, with the other counties, is that today thing or is that an all week thing? What is it?
I've got something tomorrow and it's in the motion that I'll be most of the day tomorrow. And then Wednesday, I've got something personal issue, but that's, takes backseat.
All right, what we're going to do then is we're going to recall this back for August 25th for you all to obtain a jury trial date.
Yes, Judge.
To obtain a date or to
Yes.
be on? Okay, I just want to make sure because we've actually looked at our calendar.
Speak to me today. What's going on?
I am.
Judge,
You understood? Thank you.
I just need to make sure I'm hearing what I'm hearing, Judge. I apologize for my density.
All right, so you're going to be back on August 25th. Could I have a reset form, please? Thank you. Here. Once you sign the reset form, you're excused.
All right, thank you, Judge. Appreciate it.
Thank you, Judge.
Thank you.
This is shocking to, working on it, kind of similar states.
All right, let's talk about that. Judge Boyd's courtroom had a steady rhythm in this hearing, and she handled the matters before her with her usual mix of fairness, structure, and the occasional touch of humanity. The main case of the day was State versus Larry R. Garcia, and what stood out was how carefully the judge walked him through every right and waiver. She wasn't rushing. She wanted to be absolutely certain he understood what was happening. Garcia himself came across as respectful and compliant, answering "Yes, Your Honor" consistently, though at times with a quiet, almost hesitant tone. He seemed to know the deal he was taking. And his attorney confirmed several times that Garcia had reviewed the documents and understood the consequences. The defense counsel did his part effectively, staying clear and organized, while the prosecutor kept things straightforward, sticking closely to procedure without any theatrics. The whole plea process was smooth, with everyone doing their jobs competently and without conflict. The highlight, however, came after sentencing, when Judge Boyd addressed Garcia directly. She noted his age, acknowledged that he would likely be released very soon based on time served, and then pivoted to a more personal conversation about what happens next. She spoke candidly about addiction, the risks of relapse, and the reality that leaving jail can feel like freedom until old habits return. Her tone was compassionate but blunt. She didn't sugarcoat the danger. And she emphasized finding a support network immediately upon release. It was less about scolding and more about giving him practical advice, almost as if she wanted him to carry her words as a safeguard once he stepped outside. That moment gave the hearing a human dimension beyond the black and white of legal procedure. The courtroom atmosphere overall was calm and businesslike, with a few lighter moments sprinkled in. Judge Boyd even made a quick joke about jacket covers on a book when dealing with scheduling, which showed her ability to balance authority with a little levity. Even when she shifted to other cases after Garcia's plea, she maintained the same even keel. Attorneys came prepared, though occasionally pressed for time, and Judge Boyd kept them on track without being harsh. By the end, the courtroom felt less like a place of punishment and more like a place of accountability paired with opportunity. In sum, this hearing had professionalism, a bit of humor. That's something you don't always see in a routine plea, and it's what made this session stand out. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.